welcoming Mr. Jeff Linden from Thav Gross, which is an attorney firm. They do all kinds of stuff. Real estate is one of those that Jeff specializes in. Jeff and I were talking a couple of weeks back, however, regarding this wonderful thing of wills, trusts, and basically estate planning. And so with that, I thought, what a great opportunity. So, Jeff, I'm going to turn it over to you and let you take over and hope that the internet continues to work. By the way, Jeff, do you need to do a share?
He's muted.
Yeah, Jeff, you're muted. There you go.
Not any longer. Let's see. Sorry about that. Let me. I think I can share.
You should be good to go with it now.
The question is, am I sharing the right thing? I can't see what I'm sharing.
You have up Thav Gross Attorneys, Jeff Linden.
Is it a full screen or is it a split screen?
It is a full screen. Okay,
great. So, good afternoon, everybody. Thank you for the opportunity to present to you. I've got, it's, a slideshow. Darwin told me, there's a limited time. So this is a high level view of basically estate planning and wills and trusts, and I'll try and save some time at the end. But a little bit about myself. This is Thav Gross Attorneys is the firm. We are located in Bingham Farms, Michigan. We service clients in matters across the state of Michigan and across the country in certain areas. We do a television podcast and radio show called Law and Reality. It airs most weeks. This is the information. We're on Channel 20, KISS FM, and the Praise Network. It's a show that talks about the law in the ways that affect most people. Often it's debt resolution, estate planning needs, tax resolution things. It's fun, and it gives a dose of reality, not just the technical stuff. I encourage you to check it out. Thav Gross has been around a while. We were established in 1982. We're a broad-based practice. We do business law, real estate, bankruptcy, probate and estate planning, as well as tax resolution and business consulting and litigation. We focus we take a business approach to our legal solutions. In other words, everybody who has a legal problem, whether they know it's a problem or not, they're looking for a solution. So we look to find the best solution, and we're multidisciplined. So the best solution in a lawsuit may not be continuing litigation. It may be some other resolution. We always look for the most economical and efficient resolution that serves the client's purposes. A little bit about me. I grew up in the area, left a little while for my education. I went to the University of Michigan in Ann Arbor for my undergraduate and out in California for my law degree. I'm licensed in this state as well as Colorado and California, although I'm inactive in those states now because I don't do much there, but I have federal bar admissions in all the federal courts in the state of Michigan, including the Courts of Appeal and the United States Supreme Court. I also serve as a panel chairman for the Attorney Discipline Board, hearing cases where people file grievances against lawyers for alleged ethical violations. So I take integrity to the practice, honesty and transparency very, very importantly in my practice. Essentially, estate planning has several basic components. You sit and you think about an estate plan, and it's a jumble of information, and where do you go? An essential estate plan generally has the goals, in most cases, of avoiding probate. You address the control issues for your life and financial matters in the event people are disabled, and you ensure that your assets go where you want them to go to the people you want them to go in the event that you pass away. I know this is a group of mostly real estate professionals, and estate planning and probate has a significant impact on real estate sales if people are dealing with properties that end up in probate or in estates because people have passed away and they haven't properly put their estate plan documentation in place. The essential components of most estate plans would be some form of revocable living trust, a pour-over will, a durable power of attorney, and a healthcare power of attorney. Those are the core elements of any effective estate plan, and they're interrelated and they work together. Most durable powers of attorney that were out there, living in this area, a lot of people got free legal services when they were in the automotive industry, union members through the GM legal service. And they'd give you a cookie cutter form of estate plan documents and things that were generated a long time ago. Most of those documents are out of date. They don't generally have the current requirements to make powers of attorney HIPAA compliant. They usually lack proper nursing home or Medicaid planning authority that give people the ability to help their loved ones, if they have agency over the power of attorney, move assets as needed to qualify for those benefits. Trusts that were created prior to 2017 often leave assets first to a family trust due to tax related planning matters for estate tax that don't really apply today, because under the current law, the estate tax exclusion, if you're a married couple and you exercise the combination that you can do, you have to have an estate that's worth over $22 million before that comes into place. That's less than 1% of the people that need estate plans have a net worth that high that becomes an issue. Those old plans don't have IRA beneficiary protections, and often they don't address the children and financial and marital issues, including asset protection, second marriages, and things like that. So you get them, they're cheap, but they're often ineffective in hindsight. The other thing that estate planning does in a will and trust is it deals with estate distribution. If you fund assets into a trust before your death, or you have proper documentation for certain other assets, then no probate is needed. Things that transfer by operation of law would be tenancy by the entireties, things that you learned in your real estate class, or joint tenancies with right of survivorship. Those pass title to the surviving co-owner on death of one of them. Beneficiary designations for life insurance policies or bank accounts that say, they're often called TODs or CODs, transfer on death or change on death. And that basically tells the contractual documents that give people ownership upon the death of the co-owner. If you don't have those, the default under Michigan law is a tenancy in common, which means each co-owner owns a portion of the property and they both have to transfer it, whether that's personal property, asset accounts, real estate, what have you. Whether or not you have a will, you will have to go to probate if you don't take steps to take your assets out of the will. Intestate is a legal term used for people who don't have a will. So effectively, everybody has a will. It's whether or not you want one provided by Michigan statutes or you want to have control over who gets what. If you have nothing, then Michigan statutes will provide who gets your property or your client's property in a way that may not be how you want. Additionally, if you don't designate things in a trust or a power of attorney for children, or you want beneficiaries, if a child under the age of 18 inherits property by law, if there's no other provision for them, that money will be put into a conservatorship. I don't know about you, most 18-year-olds I know are not financially responsible. So if a parent passes away and they have life insurance or a house and a child inherits a few $100,000, even $50,000 from a parent, under the conservatorship law, they get full access to it unrestricted at age 18. My experience, most 18-year-olds that find themselves with, $100-something thousand are going to go buy a bar, a Corvette, possibly a boat, and then that money's gone. So a trust and estate planning is another way that people can protect their children from their financial immaturity. Trusts are controlled by contract principles. It's a contract between yourself and your beneficiaries, and a contract between yourself and your designated trustee. 99% of the time, your trustee initially is going to be yourself. And other than changing title documents, it's not going to change how you construct your life or deal with your financial life. The other advantage of a trust is it's private. If you go to probate court, it's a public record. Not that it's broadcast over the news or anything, but anybody that can go to probate can see the pleadings that are filed there. That means they can look at the will. They can look at the beneficiary designations in the will. They can look at any disagreements or fights that are going on in probate court. It's all public record. A trust happens outside of probate court. A trust appoints a person, trustee, to handle your financial affairs, following the contract guidelines of the trust. It all happens outside of court. Nobody other than those affected are entitled to know what's going on. So it's very private and efficient. Trusts also can protect your beneficiary's inheritance from a bankruptcy trustee if somebody has to file bankruptcy, because a trust, if it's discretionary, can keep assets out of the control of the beneficiary until the trustee decides what to do. Apologize for the interruption. Problem areas that happen with estate planning are often second marriages. The husband leaves money to the wife leaves money to the husband. If one predeceases, then the money goes to the kids. That's the typical thought process of most people. What happens usually is second marriages. Wife remarries, leaves the estate to a new husband. Wife remarries and gets divorced. And I'm not picking on women or men here. You have to go one way or the other. It's a 50% choice of whether you choose the husband who's the one getting remarried and leaving it to the new wife, or the wife. In our examples, we just chose this one. Sometimes the wife doesn't want to leave the money to the children. There's a breakdown in the relationship. This can create problems. This is a common problem with mingled marriages or later in life marriages, second marriages, where each member of the marriage is bringing children to the family. Sometimes the plan, when one of the spouses passes away, the surviving spouse doesn't necessarily feel close to the children of the deceased spouse. So the deceased spouse needs to take, everybody needs to take precautions in their estate plan to make sure that the people that they want to benefit and take care of later in life will be cared for in the way that you want, and that after you're gone, somebody can't undo that and do something different than your expectation. That can be done through careful and effective estate planning and trusts. I'm going to skip ahead. Another thing that a trust does is creditor protection. And we talked about children and what they could do if they have creditor issues or other beneficiaries of creditor issues, if they're too young or immature, or if they get divorced. You can use the trust to protect them. As I said, you can put discretionary provisions so that the trustee has discretion on when to dole out the money for certain enumerated expenses. Education, health, maintenance, welfare, support are common categories, instead of just dispersing the money outright. So for an example, if a child has racked up extensive credit card debt, and they're the beneficiary of a trust, and their parent passes away and they're going to inherit $700,000 and they owe $150,000 in credit cards, can the credit cards get that money? No. In a discretionary trust with the proper language, the trustee doesn't give the child the money. The trustee can pay the child's rent, can pay the child's bills, utilities, medical expenses, educational expenses directly, and the creditor would have no way of attaching that money. It would protect the child from its own financial indiscretion. That child needs to file bankruptcy or things like that, that can also help protect them. And then once that money goes from the trust to the child, at that point, the creditor can attach it. So trust can be used to avoid that, or at least give maximum protection that you can under the law to protect those things, except for the IRS. The IRS is what we call a super creditor. They can get to everything, including qualified retirement accounts. No other creditors, banks, mortgages, credit card companies can get money that's held in a qualified retirement account. The IRS can. This is what I was saying. IRAs and 401ks are protected from your creditors, not the IRS. We already covered this part. Durable powers of attorney. People will often not do a will or a trust because they'll say, well, I've given Junior power of attorney. Powers of attorney can be limited or extensive. Powers of attorney are useful in lots of ways. The authority given by a power of attorney is always revocable by the principal, the person who provides the power, unless it's durable. Well, not unless it's durable. It's always revocable as long as the principal is competent. A durable power of attorney is a special animal, and that survives that person's incapacity. And what does that mean? So if I gave you, or I gave Darwin power of attorney for me, and he's my agent, and I gave him full authority to do the universe of things he could do, he has that authority up until the point that I die. Once I die, he no longer has that authority. So a power of attorney doesn't help you in the event of somebody's passing with regard to transferring property or dealing with bank accounts or expenses after death. It's only during your life. If it's not a durable power of attorney and I become mentally incapacitated during the timeline of the power of attorney, Darwin's ability to conduct business for me also dies because it's linked to my capacity. Unless it's a durable power of attorney in which we put in special language to make sure that that authority lives beyond our own incapacity. And that's the point of those. The point of having a power of attorney in this circumstance for estate planning purposes isn't just the convenience of having somebody else be able to do your stuff just because you don't feel like it, but it's so that you have somebody who can take care of your expenses and bills and sign contracts, hire help for you when you're no longer able to do so, but still living and needed. That's where it becomes most effective, and that's where it's most critical. They can be immediate or they can be springing. What that means is that you can put a condition in there that the authority given to Darwin and my power of attorney only becomes active if I become unable to act for myself because of some physical or emotional or mental disability. That's a springing power of attorney. An immediate power of attorney provides the authority the moment the documents are signed and accepted. I'm chattering away here, just going, I don't have a full screen of all the participants, but if somebody wants to ask a question, I'm happy to take a question at any time, or I'll try and leave time at the end as well. Powers of attorney can be revoked by any competent person at any time. They're not cast in stone. So if you change your mind and the person you've designated as your agent you no longer want to be, you're perfectly able to change that. That's a little graphic about springing power of attorney. I'm going to get to the healthcare power of attorney. That is the classic type of springing power of attorney. Healthcare powers of attorney in Michigan are usually called designations of patient advocates. So you have a medical advocate to advocate for you in terms of medical care, agree to consents for medical care, declinations of medical care, organ donation, life-saving features, do not resuscitate orders, organ donation, and whatnot. Those by law are necessarily springing, meaning they don't come into effect until you as the person involved is no longer a judge capable of making your own medical decisions. So if you do a durable power of attorney for healthcare or a designation of patient advocate, you don't have to worry that the bad child is going to hospitalize you or give you care you don't need or not give you care that you need, as long as you're able to make your own decisions. You go in, the doctors will talk to you. It's only reserved for the case where you can't, because you're either unconscious, you don't have mental capacity, you're in surgery, or something like that, and they need consent. That's when the medical power of attorney kicks into place. And you can take care, they're sometimes called living wills too. The living will portion of a medical power of attorney or durable or designation of patient advocate is, you also call them advanced directives. It's when you designate what future services, most often in extraordinary care, life-saving measures, CPR, tube feeding, IVs, heroic measures, that you want or don't want. And you can be as specific or as general as you want. You can dictate, in this circumstance, I want A, B, and C to happen in that order. You can leave it generic. You can tell that I have my designated person and I trust their judgment and they know what to do and they have the full authority. You can be as general or as specific as you're comfortable with and want. Young adults. This is something I talk about with Darwin in our meetings a lot that most people don't realize. If you have children, they grow up and you grow up with them taking care of their needs. They have problems, you get involved. As soon as they turn 18, you no longer have the legal authority to do that. If your child wants to go to a doctor, they can do that without your knowledge or consent. If you have a child in college in dealing with the tuition bills or the academic contracts dealing with college. You don't have authority to deal with that unless that's given to you. If you have a power of attorney signed by your child at the age of 18, then when this happened to me one time, and it happened to a colleague of mine, one of my kids got a bill from University of Michigan that had an extra zero in it. So instead of $5,000 bill, it was a $50,000 bill. He didn't know how to handle it. He'd never experienced that. He was 18 years old. Because I have power of attorney for him, I could call financial services and they were willing to talk to me about it and resolve the problem. Same thing with bank accounts. Same thing with medical care if you're traveling with somebody, out of the country. If you don't have the authority, then you may assume that you can do things for your child that you don't. If you're remarried and you have a stepchild and you travel with that stepchild, you're not an heir, you're not a designated person. You don't have legal authority to help that child with medical decisions or other things, even though they may be your primary responsibility. These are the types of documents that, if that's your situation, that you can execute to help take care of that. I do probate as well, and I do the problems that come up with probate. In my view, you don't have to tell anybody what your estate plan is, who gets what your wishes are. My personal experience, having been a lawyer for about 30 years now, is that that's the worst approach. Transparency is the best approach. If people know what's coming, they can deal with it better, even if you're not going to leave money to a child. I have several clients that effectively disinherit one of their children, or they don't leave an equal amount to everybody because Billy Jr., is a neurosurgeon who makes $700,000 a year and was well invested and is a multimillionaire. Sarah Jr. was an artist and he maybe makes $30,000 a year and is struggling. In the parent's conception, Sarah Jr. needs a little bit more financial help later in life than Billy Jr. does. Billy Jr. is fine. He's not going to need it. If you explain that when you're going through the process and they know, then when there's an unequal distribution or somebody's left out and they know the reason why, more often than not, there's not going to be a fight about it. When you keep people in the dark and they're surprised by the results, then there can be a fight about it, and everybody has the right to hire a lawyer, go to court and object and try and get an estate plan undone if they think that mom or dad was mentally incapacitated at the time, or that Junior exerted undue influence over their parent, or threatened them, or they were under duress, or kept them isolated and things like that, and forced this different distribution. Those are things that happen. I deal with that in court all the time. That can usually be avoided in most cases if the family knows what your intentions are. That's usually the best practice. It's also the best practice if, even without disputes, that in the event of something happening, and this came up a lot during COVID when people became suddenly very, very ill and couldn't handle things for themselves, that your family knows where your things are, knows where your bank accounts are, knows who your financial advisors are, knows who your attorney is, knows who your real estate broker is, knows the access codes to get into the bank account, or at least where you keep them. Because if you're in the hospital for 3 months and you can't pay your bills, who's going to do that for you if you haven't prepared? Critical points that we have come across with regard to your finances to not do. Protect your retirement accounts. Don't raid them to pay credit card bills or a house that's underwater. Okay. Bankruptcy is usually there to help protect you from debts that you can't afford. Creditors, banks, credit cards, other mortgage lenders and things like that, they cannot get your retirement accounts. When you're young, you can save. If you're older, it's harder. Once that money's gone, it's a lot harder to build that nest egg. That's there for you. Keep it there. There are other tools that we can provide to help people out of debt trouble. This happens a lot. Try not to jointly title assets. That's sort of the old view. It works still in some limited circumstances. A lot of people default to it. A lot of people do it because you don't have to meet with an attorney. You avoid the cost of doing an estate plan. It can create all sorts of problems. If you jointly title assets and you run into issues where people have debts or bankruptcy or other issues, both of you own 100% of the whole thing. So that asset becomes liable, your share of it becomes liable to the other person's debts and creditors if they're jointly titled. So it's you can take care of it through a trust, you can take care of it through powers of attorney where people have access and use of the funds as needed, and passing on death and things like that without exposing them to creditor seizure. As I said before, the discretionary trust solution is what you do to protect creditors. You give the trustee, whoever that's going to be, the discretion to choose whether or not to hand out the money for the certain enumerated types of events. It's called a spendthrift provision. It protects the beneficiaries from that issue. On the flip side of estate planning is what you're doing a trust in an estate plan to avoid: probate. As real estate professionals, I'll go through the general probate process, but as real estate professionals, you're going to come across houses that are going to be sold by people who inherited them, or people that think they inherited them, but nobody took the measures to go through probate to get the title into the house, into the right people. So probate, I don't know if you can see the little window here, it says the validity of a will before a judge. So what probate does is it's a judicial decree that the will is valid and it should be followed. Trusts are not probated. Powers of attorney are not probated. Probate court is the vehicle that wills are probated. Intestate succession, if you don't have a will, matters are handled, and guardianships and conservatorships are also handled through probate. What the probate court does is when you die, if you don't have a trust, your assets have to be transferred either by the will or by the intestate succession laws. It's the process of proving the will and getting court orders to give the fiduciary, the person who's going to be in charge, the legal authority to transact that business. I think we're running a bit out of time. A couple of key points about probate is it's necessary to transfer real estate in a formal proceeding where it's supervised. You can't transfer real estate without a court order if it's a supervised probate. That's something real estate professionals should know. Another thing that real estate professionals should know is the Seller Disclosure Act. Generally, if a house is being sold by court order or probate court order or by the personal representative or fiduciary of a will, the seller disclosure doesn't apply. You don't have to give that disclosure. But if they do, they risk themselves opening themselves up to liability for a false disclosure or an incorrect disclosure. You guys are all familiar with the seller disclosure requirements in real estate, but if you're dealing with a fiduciary or a probate house, you want to be careful. You know, maybe it's best to have that fiduciary say nothing and give notice that I'm not subject to the seller disclosure laws. I'm just stepping in to sell the house. I don't know the condition of the house. As opposed to once they say, oh, there is no known water leak problem, there is no known radon problem, and they're wrong, they've exposed themselves in the estate to liability. It's different than the normal seller-buyer relationship. That's a highlight. I'm happy to give my information was on the front slide. I'll go back to that now, so it's there. I can take any questions if time allows.
I think you did a great
thank
job.
you for the opportunity.
Yeah, I think you did a great job here. I think maybe I might have missed it, but did you cover the difference between revocable trust and irrevocable trust?
I didn't. So a revocable trust, there are two types of vehicles. A revocable trust can be changed by what we call the grantor or the settler. So if I'm creating a trust for myself, I'm the grantor or settler. Revocable trust means I've retained the authority to modify it or revoke it at any time. That kind of trust is invisible from the standpoint of the IRS. If you transact business as a trustee, your social security number is used, things like that. An irrevocable trust is just that, it's irrevocable. You're giving property away to the trustee. The trustee can't be yourself. You can't have control over it, but you can retain control over who the trustee is. And in those circumstances, you do that with life insurance sometimes or real estate sometimes. It's a good way for tax planning to divest yourself of the tax consequences and ownership, but still retain some use or benefit depending on how the trust is created. We use those for Medicare or Medicaid planning. We use those for asset and creditor protection because the asset is no longer yours, even though it's being used to benefit you by the trustee. But ultimately, it's going to be given and passed on to somebody else, and that can't be changed. So if you want to do that for tax, debt, or other purposes, it's a tool that's used often, but you have to be willing to know that you're effectively giving up your ownership of that property, whether it's personal property or real property, when you put it in an irrevocable trust.
And then I think probably, Jeff, just the last one, if somebody wanted to think of it from that point, it's what, 5 years that it has to be, they have to be thinking
Medicaid planning. If you so the average cost of retirement or not retirement care, but nursing home care, if somebody has to be put in a full facility for nursing home care, is between $10,000 and $12,000 a month. Most people don't have, if people don't have the resources put away for that, to pay for that, then they're going to want to seek assistance through Medicaid. Medicaid can pay for much of those beds. But Medicaid, to be eligible, if you have assets, let's say you have assets, but you don't have enough. If you want to, you can divest yourself of assets and plan to be eligible for Medicaid. But Medicaid looks back 5 years. So if you've sold a house, transferred property within 5 years, Medicaid program will ignore that and treat that as an asset of yours. So if you want to do Medicaid planning and prepare for the eventuality that somebody may need Medicaid to assist with nursing home care, you have to do it ahead of time, and you got to start planning 5 years ahead to do it effectively. You may hear phrases like half a loaf. There is the half a loaf solution, which is if you're within the 5-year window, we can protect some of it, but not all of it.
Wonderful. So guys, I know we got a little late start. Technology is always an awesome thing. And Jeff and I, when we talked, we knew he was taking about an hour and a half and trying to put it into 30 minutes. And my friend, you did an awesome job.
Thank you.
So Jeff's got his information here. If you or someone you know may need any type of this type of planning or assistance, Jeff does a fantastic job. And of course, check him out on the weekends on TV and on the radio. So with that,
if
Jeff,
I could
any
just
closing
real quick,
thoughts?
Darwin, one thing that comes up with my practice with tax resolution is tax liens. We do a lot of tax lien issue, and when real estate is sold with tax liens and getting those liens discharged, that's a good part of my practice. So if that comes up in your transactions, please consider giving me a call. I can help with getting the tax liens discharged or dealing with the proper paperwork with the IRS. What you should know in that regard is that the typical processing time for discharge of a tax lien is at least 45 to 60 days. So you need to factor that in when you're setting your closing deadlines.
Fabulous. All right. I appreciate it, my friend. Thank you for your time and your education for us today. And guys, that wraps up another Hot Topic Tuesday. Remember, next week, we will not have it. July 5th, we will not. We'll be returning on July 12th. So everybody have a great one. Go talk to people. Thanks again, Jeff.
My pleasure. Have a good holiday, everybody.